Hi everyone, good evening. Thanks a lot for joining us today. I'll be presenting Excadia's work on estimating adjournment rates using some data from courts. So we've all heard multiple instances of the Indian courts granting several adjournments in many cases, but how many such adjournments happen per case? What are its implications on the case disposal time? Or at what stages do they occur most frequently? These questions largely remain unanswered. So why do we want to answer these questions? Why do we want to measure adjournments? One of our prior works, we came up with a set of 5 metrics that determines the performance of the judicial system from the lens of what a litigant expects from the justice system. So one such key expectation of a litigant is the ability to have certainty or predictability on the trajectory of his case, and information on whether a particular case listed on a particular day will actually be heard on that particular day is a key element of this certainty. Also, because legal fees, your counsels and attorneys charge clients per the number of hearings, and these charges vary depending on whether the hearing actually took place or not, is a key element that goes into factoring cost for the litigant as well. So a case goes through multiple hearings before being disposed of. We know that. However, many things can happen in any hearing. The idea of adjournment that we all think of means a particular case could not be heard on that date, maybe due to paucity of time, it was lower in the cost list, or the parties sought adjournment. But there are other things that can happen in a case which does not necessarily mean that the case progressed. For instance, the judge is merely taking on record some submissions or directing the registrar to send notice to a party to appear before them. So these cannot be put into the ambit of adjournment in its actual sense, but nevertheless, from a litigant's point of view, it does not really move the case any forward. Some prior attempts have been made. For instance, the Ministry of Law and Justice, in one of its office memorandum, used the expression effective hearing to mean substantive hearing in the context of how much should the government council be charging for cases. And Prashant Reggie and Shubho have worked in the context of DRT, where they use the term failed hearings for a non-substantive hearing. So how have we bifurcated substantive hearing from non-substantive hearing? So the first one is quite straightforward. Any express adjournment, simply a next date is given. We term it as non-substantive hearing. Some instances for what we look for in the order which comes out of the hearing of the case includes adjourn due to paucity of time, time sought by parties, non-appearance, technical glitches, etc. In the second instance, in any hearing where the court merely gives direction to file pleadings or takes on record some pleadings. For instance, counsel for the respondents is directed to collect the court notice. This is an extract from an order itself. We term this as non-substantive hearing as well. What do we mean by substantive hearing? Any form of application of judicial mind causing the case to progress. So if the counsels were heard, there were arguments, the case was disposed, settlements were reported, etc. So there were some challenges in dividing these hearings into substantive or non-substantive. For instance, if we were to just look at some of these keywords and bucket into substantive and non-substantive hearing, every judge has their own method of writing up an order. So sometimes a judge might say, the previous hearing was adjourned, in this hearing we heard the counsel. So then where do you classify it if you're just going by the mere words of it? So there was a bit of application of mind and subjectivity that we had to incorporate into this exercise as well. So what is our work? We manually passed the orders for about 600 cases, which comprise 2000 orders for one case type in India, that is debt enforcement cases. And we classify these hearings into two categories, the substantive and non-substantive categories. As I mentioned earlier, every judge records an outcome of a hearing in their own language, and the classification needed some level of subjective judgment, application of mind, some legality, legalese, expertise, etc. However, to minimize the scope of subjectivity, we also subjected the analysis to double-blind peer review. This is the team that worked on it. We went through multiple rounds of revisions, debates, arguments within ourselves, and we started this work in last July, and we are here now. Okay, so we collected data from 3 debt contract enforcement court in Mumbai, the Bombay High Court, NCLT Mumbai bench, and DRT Mumbai bench. At the Bombay High Court, we selected specific 3-4 case types which we thought had a debt contract enforcement element to it. So it's civil suit, commercial suit, summary civil suit, and commercial summary suits. The NCLT deals with IBC and Companies Act, so we have both the cases. And the DRT deals with the SARFAESI Act and recovery of debts due to banks and financial institutions, and we took all the cases. So we have a parent data set which spans across about 4,000 cases at the High Court, 10,000 cases in the NCLT, another 4,000 cases in the DRT. But since it was manually read, we restricted to a small sample size of 200 for each court. We selected the sample based on, it was a stratified sample in the sense we collected 100 pending cases and 100 disposed cases for each of these courts. So we totally have about 600 cases. And the second table gives you the division on how many hearings happened in these 600 cases. Bombay High Court had the least number, 341 orders, NCLT about 1,000 orders, and DRT about 500 orders. So about 15% of the cases at the Bombay High Court, not even a single hearing had been held. So you can see that the minimum hearing per case at Bombay High Court is 0. Maximum is 11. NCLT has had the most number of both median and maximum hearings, and DRT is in the middle, like 3 median cases and maximum 14 cases. Okay, so how many substantive hearings does a case involve? So what we have done is we have looked at every single case and bifurcated the number of substantive hearings in that particular case and the number of substantive non-substantive hearings in that particular case, and we took the median calculation for it, and across all 3 courts about 50% of the hearings or lesser conducted in a case are substantive. So what does it mean? Both at the Bombay High Court and the DRT, about half the litigants get 1 substantive hearing for every 2 hearings. At the NCLT, they get 1 substantive hearing for every 4 hearings. So NCLT is kind of the lowest ranking in this case. Next, we go to find out about facts about first substantive hearing. So a first hearing is important for any case. Depending on the adjudicating forums, it has arguments on questions of admission. It's the first time a judge applies his mind to a case. Interim relief gets heard on that case, which operates pending the disposal of the case, and so on and so forth. In a previous article, we showed the chances of a litigant getting a first hearing in the first year of filing a case for these 3 fora. So in this, we wanted to see how long does a litigant then have to wait for a first substantive hearing across these 3 fora, because we saw that first hearing does not really have to mean first substantive hearing. Okay, so this table gives you which nth hearing of a case was the first substantive hearing. On the right hand side, you see the case count. How many cases at the Bombay High Court had a first hearing itself which was substantive? How many cases in the Bombay High Court had a second hearing which was its first substantive hearing, and so on and so forth. And we see that both Bombay High Court and DRT, about 50% of the cases get a first hearing itself, which was substantive, whereas in case of NCLT, it's only about 23%. And in fact, about 9% of the litigants have to wait till a sixth hearing to get a first substantive hearing in their case. And the last row gives you the number for the cases where no substantive hearing has taken place so far till our date of scraping this information. And that's the highest for the Bombay High Court. So while you see that in DRT, about 50% of the litigants get a first substantive hearing at the first hearing itself, the distance between filing date to the first substantive hearing is much larger in the DRT as compared to the NCLT. And similarly, the age of pending cases which have not had a first substantive hearing at all, it's about 2 years and 2.5 years for Bombay High Court and NCLT, whereas for DRT it's about 8 years. So how does an early substantive hearing relate to disposal? So we do not go into any causal inquiry. We are just doing some early investigation as to whether a first substantive hearing has any relation to disposal across these three courts. So we find that at the Bombay High Court, the evidence seems to be the strongest, where cases which have got a first substantive hearing, 81% of them were disposed of, whereas only 23% of cases which have not had a first substantive hearing have disposed of. In the NCLT, it's about 30% of the 70% of the cases which were disposed of had a first substantive hearing. In DRT, we find the weakest evidence that it's almost the same whether you get a first substantive hearing or not. Then we try to look at the time to disposal from filing for cases which have had a first hearing which was substantive and first hearing which were non-substantive. Unlike the previous where we saw the strongest evidence for the Bombay High Court, here we see the strongest evidence for the NCLT, where the cases which had a first substantive hearing were disposed of 3 times in lesser time than the cases which did not have a first substantive hearing. And for DRT, it's about 1.5x times, and at the Bombay High Court, it's about 1.3x times. So our findings are limited to debt disputes only before the Mumbai bench, but we believe this approach can be scaled across India. And if we were to look at justice delivery as a service, information that gives litigants certainty on these basic questions is a critical element, and courts as service providers should be providing this information. And we also believe that this approach can be deployed to other case types, and it can also have implications for judges and the court registry itself. For instance, we saw about 50% of the hearings at any given point in any case is non-substantive. So that clearly has some court docket issues, case management issues. So we believe this can also help them in addition to the litigants.
Hi everyone, I'm Mugdha, and I'll present to you some ways in which we applied the substantive order identification to other case types. Here we'll be looking at the motor vehicle accident claims and check bouncing cases. So in Pavitra's presentation, she covered how this information about the causes of non-substantive, the existence of non-substantive hearings is really helpful for the litigant. Here we are looking at it from the perspective of a court and reforming the process through which these cases go through. Motor accident, we picked motor accident cases and check bounce cases because they constitute 10.74% and 10.2% of all pending cases in courts today. So the motor accident claims cases are decided in a motor accident claims tribunal, which follows a civil procedure, while check dishonor cases are decided in a criminal court and follow the Criminal Procedure Code as well as the Negotiable Instruments Act. Here, the Supreme Court has passed several judgments. For instance, Gaur Mohammed most recently in 2020 for motor accident claims. And right now, there's a case ongoing called Makwana Mangaldas, where the Supreme Court has passed multiple orders in how these cases can be made faster. Their identification of the problem largely lies at the summons stage, And they've passed a bunch of directions, for instance, affidavit to be given in lieu of evidence. But there is no scientific analysis of what is it that courts are wasting their time on. So using the substantive order identification will help us understand the bottlenecks of the process, then identify the stages at which these bottlenecks occur, and then to the identification of substantive orders, we added an attribution element. Who is responsible for the non-substantive hearing? If we identify that, it will help us understand what interventions are helpful, most helpful, or least helpful. For this, we looked at only disposed cases of both types. So 100 motor vehicle accident claims from Rajasthan, Tamil Nadu, Telangana, and Delhi. Of course, the numbers are a bit odd because we found that, for instance, in Karnataka and Rajasthan, the data quality was really poor, which also leads to a limitation of this method, is that in order to do substantive order analysis, you need orders that are descriptive to some degree, that go beyond saying heard or adjourned, and which also recognize the stage at which the case is at, or at which stage did the hearing take place. So these are the cases that we looked at. The findings for motor vehicle accident claims was that 2 out of 8 hearings per case on average were substantive hearings, and 3 out of the non-substantive hearings are spent at the stage where parties are required to appear before the court. From the attribution exercise, we realized that 58% of the non-substantive hearings were because the parties failed to appear before the court or had not satisfied their duty. So here, because this case type follows the Civil Procedure Code, the court reform has always focused on pushing the burden onto the police in terms of collecting all the information on a third-party motor accident claim and presenting it before the court, or using the and very creatively in Delhi now they use non-bailable warrants to secure the appearance of a driver, owner, and insurance company. These are the solutions that have been focused upon. But from our analysis, we realized that there is already an existing tool to minimize the non-substantive hearings because of non-appearance and non-compliance, which is that you set a party ex parte, which is you proceed in the civil case without the responding party, or you impose costs on the responding party so that they are prompted to appear. The other thing that feeds into the reform is that we need to ensure that adequate delivery of summons is ensured, and that all forms of delivery of summons are relied upon. The next way, in the check bouncing case, this was a lot more complicated because this is a criminal matter. Here we saw that 3 out of 8 hearings were substantive hearings, and 49% of non-substantive hearings were actually attributable to the court. Here the court, because the judge was transferred, or there was a court holiday, or the Lok Adalat had not forwarded its decision to the criminal court, there was a hearing failure. Here, the court reform should focus on better planning around judge holidays and transfers, to not list cases if they cannot even be heard on that day, to not have hearings. And the most important part is that because of the criminal nature of the offense, none of the civil alternatives that exist for an MV Act case can ever be used here. This also helped us understand the incentives of parties, that the court will not proceed ex parte, cannot proceed ex parte, cannot impose costs, because if it does so, it's a violation of the criminal procedure. So this is one way in which we used the substantive order identification and then the attribution of substantive order identification in order to provide concrete suggestions for court reform. That's it for my presentation. Thank you.